right to a fair trial is one of the cornerstones of modern legal systems and democratic societies. It ensures that every person accused of a crime or involved in a legal dispute is given a chance to present their case before an impartial court under established legal procedures and with respect for fundamental rights. Without this principle, justice would not only be unattainable but would also lose its legitimacy. This right protects individuals from arbitrary state power, guards against wrongful convictions, and upholds the rule of law. Historical origins. The roots of the right to a fair trial can be traced back to ancient civilizations, where early notions of justice emphasized impartiality and due process. In ancient Greece, citizens had the right to defend themselves before juries. Similarly, Roman law established procedures to ensure that trials followed predictable rules, preventing abuses by magistrates. In medieval Europe, the concept matured through the influence of canon law and early charters of rights. The Magna Carta of 1215 was particularly influential, declaring that no free man shall be punished except by the lawful judgment of his equals or by the law of the land. This principle laid the foundation for the rule of law and influenced constitutional developments worldwide. Over the centuries, philosophers such as John Locke, Montesquieu, and Cesare Beccaria argued that justice systems must protect individual freedoms, presuming innocence and providing due process. These ideas inspired modern constitutions, including the U.S. Bill of Rights, 1791, and the French Declaration of the Rights of Man and of the Citizen, 1789. Modern legal frameworks. Today, the right to a fair trial is enshrined in international human rights law. Some of the most important legal instruments include 1. Universal Declaration of Human Rights, UDHR 1948. Article 10 declares that everyone is entitled to a fair and public hearing by an independent and impartial tribunal. 2. International Covenant on Civil and Political Rights, ICCPR 1966. Article 14 elaborates detailed guarantees, such as the presumption of innocence, the right to counsel, the right to examine witnesses, and protection against self-incrimination. 3. European Convention on Human Rights, ECHR 1950. Article 6 establishes the right to a fair and public hearing within a reasonable time by an independent and impartial tribunal. American Convention on Human Rights, 1969, and the African Charter on Human and People's Rights, 1981, similarly affirm the principle, ensuring it is recognized across continents. Domestic constitutions and national legal systems also adopt these protections, often expanding them further, in line with local traditions and judicial interpretations. Essential elements of a fair trial. The right to a fair trial is not a single rule, but rather a combination of guarantees that ensure justice. These elements include 1. Presumption of innocence. Every accused person must be considered innocent until proven guilty. This prevents unfair treatment and ensures that the burden of proof lies with the prosecution. 2. Equality of arms. Both the prosecution and defense should have equal opportunities to present evidence, call witnesses, and argue their case before the court. 3. Right to legal counsel. Accused persons must be allowed to have a lawyer of their choice or be provided with legal aid if they cannot afford one. Effective legal representation is essential to balance the power between individuals and the state. 4. Public hearing. Trials should be open to the public to ensure transparency, except in cases where privacy, security, or the rights of others require limited access. 5. Independent and impartial tribunal. Judges must be free from political influence or personal bias. Independence safeguards the credibility of judicial decisions. 6. Reasonable time. Justice delayed can amount to justice denied. A trial must take place within a reasonable period, preventing prolonged uncertainty or detention. 7. Right to appeal. Individuals should have the opportunity to challenge decisions in a higher court, ensuring oversight and correction of errors. 8. Protection against self-incrimination. Defendants cannot be forced to confess guilt. Coerced evidence is inadmissible in fair trials. 9. Right to interpretation and translation. Non-native speakers and persons with disabilities must be provided with interpretation services to understand proceedings fully. Together, these elements safeguard justice and maintain the trust of society in the legal system. Challenges to the right to a fair trial. Despite its recognition, fair trial rights are often threatened in practice. Some key challenges include 1. Political interference. In authoritarian regimes, courts may be influenced by government interests, compromising impartiality. Political prisoners and dissidents often face sham trials. 2. Inequality of resources. Wealthy defendants can afford top lawyers, while poorer individuals may depend on underfunded public defenders. This disparity undermines the principle of equality before the law. 3. Delays in justice. Overloaded court systems and bureaucratic inefficiency result in long delays which violate the right to be tried within a reasonable time. 4. Media influence. Pretrial publicity can shape public opinion and prejudice jurors, making impartiality difficult to maintain. 5. Terrorism and emergency laws. States sometimes restrict fair trial rights in the name of national security, introducing secret evidence, military courts, or indefinite detention without trial. 6. Technological challenges. With the rise of digital evidence and artificial intelligence in legal systems, questions arise about transparency, algorithmic bias, and the ability of defendants to challenge such evidence. Fair trial in comparative perspective. Different legal traditions approach the right to a fair trial in unique ways. In common law systems, e.g., the United States, United Kingdom, jury trials play a central role with strong emphasis on oral arguments and adversarial procedures. In civil law systems, e.g., France, Germany, trials are more judge-driven, with written evidence and investigative judges playing key roles. International tribunals, such as the International Criminal Court, ICC, and ad hoc courts like the International Criminal Tribunal for the former Yugoslavia, ICTY, have also had to uphold fair trial rights in highly complex contexts. These courts balance the rights of the accused with the need to deliver justice for victims of war crimes and crimes against humanity. Importance for society. The right to a fair trial is not only about protecting the accused, it also strengthens society as a whole. By ensuring justice is delivered impartially, it reinforces public trust in the legal system. It also prevents abuse of state power, ensuring that governments cannot arbitrarily imprison or punish individuals. Moreover, fair trial guarantees are essential for protecting other human rights. Without the possibility of a fair hearing, individuals cannot effectively defend their freedoms of speech, assembly, or property. The right thus functions as a gateway to justice across all areas of law. Case studies. Gideon v. Wainwright, U.S. 1963. The U.S. Supreme Court ruled that states must provide legal counsel to defendants who cannot afford one, a landmark in strengthening fair trial rights. Öcalan v. Turkey, ECHR 2005. The European Court of Human Rights found that the Kurdish leader Abdullah Öcalan had not received a fair trial due to lack of impartiality and limited defense rights. Nelson Mandela's Rivonia trial, 1963 to 1964. Though politically motivated, Mandela used his trial as a platform for justice, highlighting how trials can expose injustice as well as administer it. Conclusion. The right to a fair trial remains one of the most fundamental guarantees of justice. It embodies centuries of legal evolution, from Magna Carta to international human rights treaties, and stands as a shield against arbitrariness, abuse, and inequality. Yet its realization is never automatic. It requires vigilant courts, robust institutions, and informed citizens who insist on upholding the principles of due process. In a world facing political turmoil, terrorism, and rapid technological change, protecting the right to a fair trial is more vital than ever. Without it, the very foundations of democracy and human dignity are at risk. Justice can only be called justice when it is fair, transparent, and accessible to all. So sources 1. Beccaria, C. 1764, on crimes and punishments. 2. European Court of Human Rights, 2025, Case Law Database, hudasi.ecarcoe.int. Please open your app to see this link. 3. International Covenant on Civil and Political Rights, ICCPR, 1966. 4. Magna Carta, 1215. 5. United Nations, 1948, Universal Declaration of Human Rights. 6. United States Supreme Court, Gideon v. Wainwright, 372 U.S. 335, 1963.